In today's video, I'm going to talk about the right to property under the European Convention on Human Rights, short ECHR. The right to property is enshrined in Article 1 of Protocol 1 to the ECHR. Thus, it is not included in the actual text of the Convention, but was added later. This does not mean, however, that the right to property was only an afterthought. On the contrary, during the drafting phase of the ECHR, there was widespread agreement that the right to property should be guaranteed by the Convention. The Convention was originally conceived as a bulwark against totalitarian system, and experience had shown that dictatorships often deprive citizens of their property as a means of oppression. Therefore, the creators of the Convention intended to include the right to property in the Convention. However, it was also clear that this protection could not be absolute. Even in democratic states, it is common practice that expropriations are possible subject to certain conditions. When drafting the text of the ECHR, the states involved had encountered problems in finding a wording that established the protection of property on the one hand, but on the other hand provided for the possibility of restrictions. Great Britain had a socialist government at the time, which intended to engage in the redistribution of wealth and nationalization of certain industry. It wanted to prevent a provision from being included in the Convention that could be understood as an obstacle to such measures. Discussions on the ECHR had been going on for a while at this point, and states were under pressure to present a result. Therefore, they decided not to include the right to property in the Convention and to postpone further discussion of it. However, after the ECHR was adopted in 1950, an agreement was soon reached. The right to property was enshrined in Article 1 of the first additional protocol. Protocol 1 to the ECHR was adopted in 1952 and entered into force in 1954. Additional protocols to the ECHR are binding only on those states which ratify them. Almost all state parties to the ECHR have ratified the first protocol, which guarantees the right to property. There are two exceptions. One is Switzerland, the other one is Monaco. As already mentioned, Article 1 of the first protocol states that the right to property is protected in principle. However, it also provides for exceptions. Interferences with the right to property and restrictions of this right are allowed subject to certain conditions. So, the structure of Article 1 of Protocol 1 is that first, the protection of property is guaranteed, and then rules for restrictions are established. The European Court of Human Rights states that Article 1 of Protocol 1 to the ECHR contains three rules. The first rule contains the principle that the right to property is protected. This rule is contained in the first sentence of Article 1 of Protocol 1. It reads, "Every natural or legal person is entitled to the peaceful enjoyment of his possessions." The second rule deals with expropriation. It is contained in the second sentence of the first paragraph of Article 1 of Protocol 1. This sentence reads, "No one shall be deprived of his possessions except in the public interest and subject to the conditions provided for by law and by the general principles of international law." This sentence says two things. On the one hand, it says that deprivation of property is possible in principle. On the other hand, it ties this deprivation to certain conditions. The deprivation of property must have a legal basis, serve a legitimate aim, and be in the public interest. The third rule deals with the control of the use of property. It is contained in the second paragraph of Article 1 of the first protocol. It reads, "The preceding provisions shall not, however, in any way impair the right of the state to enforce such law as it deems necessary to control the use of property, in accordance with the general interest, or to secure payment of taxes or other contributions or penalties." Thus, it is made clear that restrictions on the use of property are permissible. For example, even if you own a car, you can only drive it if you have a driver's license, if the car is registered, and if you have the required insurance. These are restrictions on the use of the ownership of that car. The rule clarifies that such restrictions are generally permissible. The second and third rules of Article 1 of Protocol 1 thus deal with interferences with the right to property. However, the European Court of Human Rights has consistently held that the three rules do not stand side by side in isolation. Rather, the second and the third rule, which deal with interferences, must be interpreted in light of the first rule, which guarantees the protection of property. From the structure of the right to property under the European Convention on Human Rights, which I have just described, it also follows how to proceed when examining whether the right to property has been violated. The first step is to clarify whether a particular measure affects the right to property. Does the activity or measure of the state, which is in question, concern the right to property at all? This question can be difficult in individual cases because the concept of property under the European Convention of Human Rights is very broad. I'm going to say a little more about this later in the video. The second step is to clarify whether there is an interference with the right to property. The third step is to examine under which of the rules contained in Article 1 of Protocol 1 the interference falls to be examined. If it is a matter of expropriation, then the second rule applies. If it is a matter of control of use of property, then the third rule applies. If there is an interference, then the European Court of Human Rights considers whether that interference is justified. It is justified if it has a legal basis, pursues a legitimate aim, and is proportionate. I'll say a little more about that later. The first question is always whether an action by the state, for example a judgment, affects the right to property, whether the right of a citizen which has been restricted is protected by the right to property, whether it is covered by the concept of property. This gives rise to the question, what is property in the sense of Article 1 of Protocol 1 to the ECHR? Property within the meaning of this provision includes, first of all, physical objects, for example furniture, jewelry, kitchen appliances. This applies regardless of whether these objects have a measurable value. In addition, the concept of property naturally includes real estate, that means developed or undeveloped land. However, property within the meaning of Article 1 of Protocol 1 is not limited to physical objects and real estate. Certain rights can also be property within the meaning of that provision. This applies, for example, to licenses. A license to exercise a certain profession or pursue a business activity offers the holder of the license the opportunity to earn money through this activity. It therefore has a value that is protected by the right to property. For example, there was a case against Bulgaria in which a bank had been deprived of its license to conduct banking business. The European Court of Human Rights considered this an interference with the right to property. Among the rights protected by Article 1 of Protocol 1 are also trademark rights. A large group of protected rights are so-called legitimate expectations. This means that someone has a legal position to which he is entitled under national law and which is protected under national law. In that case, he has a legitimate expectation to keep or realize this right. An example of such cases are pension rights. A person who pays into the pension fund is thereby entitled to a certain pension. If this pension were simply cancelled or reduced, the legitimate expectation of receiving the pension would be impaired. This is an interference with the right to property. However, this does not necessarily mean that the right to property was violated. As explained, the finding of an interference with the right to property is only one step in the test. Interferences, such as a reduction in pension, may be justified under certain conditions. Another example of protected rights are valid judgments regarding a claim. A person who has a final judgment for payment of a sum of money has an expectation that he or she will receive that amount. This position is protected by the right to property. There are, of course, cases in which the claim cannot be realized. For example, because the debtor has no money. This does not give rise to issues under Article 1 of Protocol 1. However, if the realization fails because the state system of enforcement does not work, this may be a violation of the right to property. There are numerous cases in which the European Court of Human Rights has found a violation because, for example, bailiffs have remained inactive for years. Once it has been established that a particular interest is protected by the right to property, the next question is whether there has been an interference. An interference with property rights is, broadly speaking, any restrictions on the powers derived from property. The clearest case is expropriation. Here, Two cases must be distinguished: legal expropriation and de facto expropriation. Legal expropriation means that the right of ownership is abolished by an act of the state. The person affected is officially stripped of his or her property rights entirely. De facto expropriation means that the affected party legally remains the owner. However, the possibility of exercising the rights arising from ownership is restricted to such an extent that this is tantamount to expropriation. An example would be that an owner of a plot of land continues to be listed in the land register but cannot use the land, cannot enter it, cannot build on it, and cannot sell it. In other words, the right of ownership is eroded to such an extent that it is no more than an empty shell. In these cases, there can be de facto expropriation. Then there's also the control of use, which is another restriction of property rights, but which is not so serious that it is tantamount to expropriation. I have already given an example above. There are restrictions on the use of the ownership of a car, but they are justified in the interest of the general welfare, and they're not so serious that they could be considered an expropriation. Once it has been established that there has been an interference with the right to property, the next question is whether that interference was justified. As I said, there are basically three requirements for this. You need a legal basis, the restriction must serve a legitimate aim, and it has to be proportional. Legal basis means that there must be a law that provides for such cases. The law does not have to regulate the specific intervention, i.e., it does not have to say that Miss X will be expropriated and will lose the ownership of her house, but there must be a general basis for expropriations of this kind. And this basis must be sufficiently precise and predictable. In other words, it must be clear to a citizen who informs himself and, if necessary, obtains legal advice that the law permits expropriations in such cases. The next requirement is that the interference must serve a legitimate purpose. This is rarely problematic in practice because the concept of legitimate aim is understood in a very abstract way. If it is said that the expropriation serves the construction of a highway and thus the improvement of the infrastructure, that can be sufficient in principle. The European Court of Human Rights then no longer separately examines whether or not the highway can actually contribute to the improvement of the infrastructure. The decisive question in examinations of whether the right to property has been violated is usually proportionality. This comes down to weighing the interest of the person concerned in being able to exercise his property rights against the interest of the general public in the restriction. These two considerations must be in the right proportion. Of course, this is difficult to measure. The European Court of Human Rights speaks of a fair balance between the various interests. It also frequently uses the formula that the interference should not impose an excessive burden on the person concerned. It is important to note that the European Court of Human Rights grants states a wide margin of appreciation when interfering with the right to property. It therefore only examines to a limited extent whether an interference is proportionate. The European Court of Human Rights grants states a particularly wide scope of judgment in the case of economic measures or decisions that affect social policy. This applies, for example, to the level of pensions or decisions on cuts on social benefits. The right to property under Article 1 of Protocol 1 to the ECHR plays an important role in the case law of the European Court of Human Rights. Numerous judgments of the court concern the right to property. Moreover, cases of the European Court of Human Rights finding a violation of the right to property are among the few in which the court regularly awards large sums for compensation to affected persons.